Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we discuss current employment considerations for businesses in the healthcare industry. We'll discuss topics such as state liability shields around the pandemic that have specific relief for healthcare-related employers, but may impose unintended liability consequences, liability risks generally, and how to mitigate enforcement risk in the post-COVID-19 era as we transition back to in-office work. Hello and welcome. I'm your host, Elena Quattrone. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our New York office, and I specialize my practice on government investigations and enforcement action. Since the start of the COVID pandemic, 33 states plus the District of Columbia and counting have enacted protections from COVID-related liability claims, either through legislation or executive orders. These liability shields are intended to provide protections for healthcare providers, businesses, and other institutions that remained open or are reopening during the pandemic. Florida is the latest state to enact such a provision, with the passing of SB 72 on March 29, 2021, which is a bill granting liability protections to businesses against COVID-19 related liability lawsuits, unless a plaintiff can show the company was grossly negligent or guilty of intentional misconduct. Effective immediately, the law applies to various government and business entities, including hospitals and nursing homes, and follows a recent push by lawmakers who are declaring liability protections as a top priority this year. On today's show, we're going to talk about these COVID-19 liability shields and how they vary at the state level with respect to the exact types of protections they create. We will also discuss some unintended liability consequences healthcare employers must consider should plaintiffs manage to clear the various hurdles imposed by the bills and other more general liability considerations employers must consider as we transition back to in-office work and reopen our businesses. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. We have two guests joining today's discussion. We first have Greg Keating, who is a member of the firm in the Employment, Labor, and Workforce Management practice in the Boston office of Epstein Becker Green. Greg draws on more than 25 years of experience as a litigator and employment lawyer, helping clients prepare for, investigate, and defend claims raised by whistleblowers. Greg also has extensive experience defending against class and collective actions arising under the Fair Labor Standards Act, Title VII, and the ADA, among others. Greg, thanks for joining us and welcome to the show.
It's great to be here.
We also have Denise Dadika here today. Denise is a member of the firm in the Employment, Labor, and Workforce Management practice in the Newark office of Epstein Becker Green. She serves on the practice's National Steering Committee and is co-chair of the firm's Health, Employment, and Labor Strategic Industry Group. She represents healthcare employers in cases involving harassment, discrimination, retaliation, breach of employment contracts, wage and hour compliance, tort claims, and restrictive covenants. Welcome, Denise, and thanks for being here today.
I'm happy to be here. Thanks, Elena.
So all industries, but arguably the healthcare industry even more so, are facing litigation risk in this COVID-19 world. These liability shields, which, as we said earlier, are legislation enacted to shield businesses and healthcare providers from COVID-19 related injury and death lawsuits, are the answer that many states have come up with to help employers in the face of litigation. Florida, which is the most recent state to pass such legislation, did so with the intention of protecting businesses from fear of frivolous lawsuits by plaintiffs who allege they contracted COVID-19 at their place of business. Specifically, Florida law SB 72 gives civil immunity to corporations, hospitals, nursing homes, government entities, schools, churches, among others, as long as the alleged negligence doesn't involve gross negligence or intentional misconduct, and provides significant legal hurdles for individuals who want to sue over coronavirus-related injuries. With that as our backdrop, Denise, I'm wondering if you can please speak to the applicability of these liability shields to employers.
Thanks, Elena. To date, there have been more than 500 lawsuits filed across the country by employees alleging their workplace is unsafe due to COVID-19. So it is a real concern for employers. And while those states with liability shields offer some protection, it's important that employers understand that none of the state liability shields provide absolute immunity for employers. For the most part, the state liability shields only protect employers from tort-based personal injury claims. So they protect businesses as well as their employees from civil suits related to actual or potential exposure to COVID-19 in the workplace that results in some type of damage from a personal perspective to the individual. They don't protect willful, reckless, intentional, or grossly negligent misconduct that results in the exposure of COVID-19. And they don't prevent employees from filing workers' compensation claims related to actual or potential workplace injury, which in many states is the exclusive remedy for claims related to the exposure of COVID-19.
So that's helpful. And it sounds like, from what you're saying, that even though this is a hot topic that's applicable to all businesses, perhaps it could give employers a false sense of security regarding protections following a post-COVID-19 return to work.
Absolutely, I agree. Because it's important to understand that the liability shields do not protect employers from the vast number of employment-related claims that are being filed by current and former employees in connection with COVID-19, such as discrimination and retaliation claims. In particular, there have been a significant number of disability discrimination claims filed under the Americans with Disabilities Act and state laws. We're seeing a lot of failure to accommodate claims as it relates to employees returning to the workplace. Employees are asking to telework or have a slightly different work schedule to provide them some protection from exposure to COVID-19 in the workplace. And failure to accommodate claims are not protected under the liability shields we've been talking about. In addition, the liability shields don't protect against other types of discrimination claims. As we see the rollout of the vaccinations, we're seeing requests for employees to be exempt from vaccination because of religious reasons, as well as due to disability reasons. So those would also not be protected by the liability shields. We're also seeing claims as it relates to leave benefits that are being interfered with or denied as it relates to COVID-19 illnesses. And then finally, the area where we're seeing the most claims is in the space of retaliation and or whistleblower, where employees are claiming that they are treated differently, including being terminated as a result of raising claims about an unsafe workplace.
So it seems like there's a bit of a heavy lift that employers may have to tackle to ensure that their employees can return to work safely in the post-COVID-19 return to work. How can businesses demonstrate their efforts in maintaining a safe workplace for their employees?
As we talked about the liability shields, it's important to understand that they're not available in the event there's gross negligence on the part of the employer. So in order to meet the obligation and not be accused of gross negligence, employers have to follow the state and local guidance as it relates to providing a safe workplace. So it's easy for an individual to show a business is reckless or grossly negligent by showing there's a total lack of effort to follow the guidance that has been provided by federal, state, and local agencies. In order to minimize claims and provide a safe workplace, employers should review the ever-changing guidance by the CDC, as well as the state and local agencies in terms of returning to work. And in addition to reviewing the guidance, it's important to put together a written COVID-19 prevention plan that would include the mitigation efforts that have been identified by the state and local guidance to maintain a safe workplace for employers in light of the pandemic. And those plans are going to include the things that we've all become fairly familiar with in terms of facial coverings, physical distance requirements, daily screening protocols, when employees should be self-isolating. In addition, both the CDC and OSHA have identified specific industry guidance for infection prevention for healthcare employers, which include enhanced sanitation protocols, additional personal protective equipment, and specific engineering controls. In addition to putting together a written prevention plan, it's important to train employees on the plan. Some states, such as New York, specifically require prevention training as it relates to COVID-19 practices. But even in those states where training is not required, we strongly recommend training so employees are aware of the safety protocols that have been put in place by their employers to ensure a safe workplace. After training, it's also important to monitor for compliance. And if employees are not following the protocols, for example, they're not wearing their mask or maintaining the distance, It's important to remind them of those protocols and discipline them if necessary to ensure that they're adhering to them. Also, it's important for employers to communicate with employees where there has been a potential exposure to COVID-19 and the steps that they're going to need to follow to protect themselves and others from the exposure, whether that's self-isolating or monitoring their symptoms going forward. OSHA also recommends that employers designate a COVID-19 workplace coordinator as your point person to address the safety issues. And that coordinator should be responsible for staying informed of the ever-changing laws, because as we've seen to date, as we learn more and more about COVID-19, the different agencies have been modifying their guidance as it relates to return to work.
Yeah, and it seems like there's so much extensive literature and changing regulations and guidance out there for these employers to get things right. So I think you really touch on just the vast impact that COVID-19 has had on our employers and, the safety as a concern on employees as we move back to work. So Greg, Denise touched on the increase of whistleblower claims in this post-COVID-19 world. With your experience in defending against whistleblower actions, what are the significant liability risks for employers, specifically healthcare companies, as we transition back to work? From a federal perspective, what are some of those concerns and trends that you're seeing?
Sure, Elena. So Denise is spot on. There is a noticeable and disturbing spike in whistleblower claims, and I don't see that abating anytime in the near future. And there's really three drivers of this. Number one, increased rights and remedies being created at the federal level, but even at the state level through new legislation. In January alone, our Congress passed 2 new federal statutes adding more retaliation protections to whistleblowers. And at least 3 states, Virginia, California, and New York, have enhanced their whistleblower rights and remedies through new legislation. So that's number one. Number two, increased regulatory scrutiny and regulatory enforcement. In the last year alone, OSHA has seen a massive spike in retaliation complaints. In the month of April last year alone, there were almost 400 complaints filed at OSHA about unsafe conditions that resulted in alleged retaliation. And this, again, is not slowing down. Add to that OSHA is likely to see stepped up resources and budgeting in the new administration. And we're going to be seeing more regulatory enforcement. Another regulatory issue that I really should mention, the unbelievable spike in activity at the Securities Exchange Commission. Last week alone, there was the second largest whistleblower award of $50 million, which brings the total in fiscal year 2021 to a whopping $250 million going to whistleblowers. And I mention that because it is fueling the plaintiff's bar. The plaintiff's bar, the whistleblower lawyers out there realize there's a lot of money in the space. And as we all know, under the False Claims Act, there's a similar bounty provision. And then lastly, Elena, the third thing is there's some disturbing trends that have just come out as a result of some very big surveys, one which was actually just reported officially today, which shows that across the country and across all industries, reporting is down. In other words, people are not coming forward internally, and there's been a noticeable decrease. The data shows that is a bad thing, because when people are not communicating with you, you do not have an ability to nip a problem in the bud when it's a small problem, and you're losing the transparency that you need in the workplace. So those are 3 things that are really driving this, Elena, at this point in time.
Yeah, I really would like to focus on the number 3 you mentioned, how reporting is down across all industries. Why are employees not coming forward and not reporting? How do you reverse that trend, and what impact does lack of reporting directly to the company have on employers?
So taking that last question first, there are some recent studies, including an empirical study backed by a review of a massive amount of data from a professor at George Washington University, that shows there is a direct correlation between increased reporting showing better results for the employer through far less high stakes litigation, far less regulatory scrutiny, and even return on investment in the workplace. In short, having your people come to you is a good thing. That not happening is obviously of concern. What's causing it? I think it's a variety of factors, Elena. Number one, the COVID era that we've been in with everybody not being in the workplace makes it harder for an employee to perhaps come forward, and therefore maybe they just go externally. Number two, social media. We are seeing so much more being commented on and brought to bear in the first instance on social media because it is so ubiquitous and it is so easy for employees to access. And number three, even the US Supreme Court has contributed to this because of a decision called Digital Realty, where they declared that to be a whistleblower under Dodd-Frank, you have to go externally to the federal agency, in that case, the SEC, and internal complaints will not give you the protection from retaliation. So those are some of the things that I think are causing it. In terms of what do you do about it? Now is the time, in my opinion, to invest in compliance. Now is the time to ensure that you foster that trust and transparency with your workplace. And frankly, I think it's a great time to really make a hefty investment because we're starting to return to work, and employers, healthcare employers, should carefully consider how we really make this a pillar of our return, that we want to hear from our people and that we want to take action that's appropriate under the circumstances.
Right. And I think that certainly circles back to what Denise was saying regarding the importance of implementing a strong compliance program that takes into account these changing regulatory requirements and the guidance that's available to employers in all industries. Shifting from the federal perspective of trends that you're seeing, Greg, my understanding is that whistleblower statutes vary state by state. Is there a different level of risk here looking from a state perspective versus a federal perspective?
For sure. I mentioned just a moment ago that at least 3 states have now embraced new legislative actions to provide more rights and remedies to whistleblowers. And that's only in the last sort of 9 months. You see a wide variety of different whistleblower protections at the state level. Many states, like where I am in Massachusetts, have whistleblower statutes that are targeted at healthcare. So if someone complains about anything that has anything to do with patient safety, they are per se protected from retaliation. Other states, New Jersey and California leap to mind, have just incredibly broad whistleblower protections for any kind of complaint, and Virginia's sort of gone in that direction with its most recent iteration. So the big picture takeaway, Elena, is an employer, particularly one that operates across many state lines, really needs to keep abreast of and be advised about the differences that can be very real depending on where you are.
So what happens then when things go sideways? Just from my practice, I often think of situations in consideration of government enforcement risk. And I'm aware that state level liability protections, such as these liability shields that we discussed earlier, don't necessarily shield employers from coronavirus related claims under federal employment statutes, such as the anti-discrimination or anti-retaliation laws. So what is the potential here for government enforcement, and how do employers mitigate against these risks? Greg, I would imagine that it has to do with compliance, right?
Absolutely. So when I speak around the country and I talk about best practices, and some of this, a lot of this comes from not only my experience, but I served on a federal advisory committee that the Secretary of Labor appointed me to, and we spent 2 years studying best practices. One of those that's directly applicable to your question, Elena, is investigation protocols. So it is so critical for any employer, but particularly in a highly regulated industry like healthcare, to have a playbook ready that you're constantly looking at and revising and tweaking so that you know who's going to be responsible for what and what kind of action you're going to take when, based on the circumstances. And there are a litany of different factual scenarios, starting with a very baseline internal employee morale complaint and escalating all the way up to an alleged violation of the False Claims Act, which trigger and implicate a whole variety of different potential players, including HR, legal, in-house, external, audit, just a whole wide variety of people. But it's so paramount that you think this through in advance, because when you're prepared, you can act much more effectively and much more efficiently. If you're not prepared, you're probably going to be pushing that rock uphill
Right. So it sounds like what you're saying is to as an employer, to really anticipate violations that could occur and have plans in place to properly address concerns before they arise. So if they do, you have a plan in place to nip it before it really escalates or gets bigger.
Absolutely.
Well, thank you so much. I think that this has been really interesting and informative just in regards to the landscape of liability risk that employers are facing in light of the post-COVID-19 return to work world. So my last question for both Greg and Denise then is, based on what we discussed today, it seems that the liability shields, though a valiant effort to protect businesses, don't address the full scope of liability risks that employers may face in this post-COVID-19 landscape. So in light of these liability risks, what are your recommendations for employers moving forward? Denise, let's start with you.
Thanks, Elena. As I noted earlier, I think it's very important for employers to have a COVID-19 safety plan in place. So continuing to maintain that plan, making sure it's up to date in terms of the state and local guidance, and regularly revisiting it and ensuring you are actually following it. In addition, as we have people return to the workplace, we're going to see an uptick in accommodation requests. So making sure that employers have a practice and policy in place for employees to follow when they need to make those requests. And by having a policy and practice, you're going to have a consistent application of the rules as it relates to accommodations. And then finally, I think the vaccination issue is going to be a big issue as we move to return to the workplace. So continuing to monitor the guidance that's been issued by the EEOC, and I'm sure we'll see more guidance going forward, so that employers can make sure that the policies or practices that they're rolling out as it relates to vaccination are compliant with federal and state laws.
Thank you, Denise. And Greg, how about you?
So, Elena, I often say when I counsel employers, and it's all the more resonant today, the best offense is a strong defense. And I think that now is again the time to invest in compliance and to at least take a hard look at and make investment in three legs of the compliance stool. And that would be take a hard look at your internal reporting mechanisms, make sure that as we return to work, you have multiple avenues for people to come forward and voice their concerns. Number two, again, take a hard look at those investigation protocols. And number three, I would strongly consider training of frontline managers, supervisors, so that they understand what is protected activity and what is an adverse action that would be retaliation. And more importantly, or most importantly, they understand the critical role they play as the eyes and ears and the antenna of the organization, so that problems can in fact get addressed and remedied before they become big problems. So those would be the three things.
Thank you, Greg. And thank you, Denise. I think you both offered recommendations that are helpful not only to our healthcare clients, but across all industries. So thanks so much for your thoughts. That concludes our program today. Thank you, Denise and Greg, for your helpful commentary and guidance as we adjust to working in the post-COVID-19 world. And thanks to all of you for listening. Again, if you enjoyed what you heard today, please subscribe to the Diagnosing Healthcare podcast wherever you get your podcasts. I'm your host, Elena Quattrone. Be well and have a great day.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.